Hi, everyone. Welcome to episode 207 of the Immigration Lawyers podcast. We have a great guest, our regular, Gregg, talking about federal court updates are happening. So we're going to jump in that in a second because a lot of big changes as every week is just constant changes in this immigration system. But before we start, I want to remind everybody that the Immigration Lawyers Toolbox magazine is out. Tons of articles, dozens of articles throughout it. We have a new issue coming out in a couple of weeks, focused just on O1A visas, but check it out at immigrationlawyerstoolbox.com/magazine. You're going to open up and be blown away of the contributions so many of our colleagues have done there. It's a really wonderful endeavor I'm proud to be a part of. With that, I want to thank all the sponsors involved, particularly DocuWise, who's also a sponsor of the podcast. You can get 10% off their annual plan by going to www.docwise.com/immigration-lawyers-podcast using the code Immigration Lawyers Podcast. DocuWise does CRM, it does case management, office management, all this different kind of stuff, and then just adding tons of stuff every day. So it's something you should check out. In addition to that, I have my own training program of how to get involved with immigration law, particularly in the family immigration space, admissibility, consular processing, adjustment of status, all that. Email me at info@immigrationlawyerstoolbox to get information for that. We have other courses going to be starting an EB5 course too. If you're interested in that, let me know. It's going to be in-depth and it's going to be a hardcore course with one of our colleagues about EB5 Immigrant Investor Program, focusing on the direct investor side, which is booming right now with all the regional center headaches. But finally, I want to also remind everybody that Gregg, our gracious guest, has his own podcast, which you all probably know about. It's quickly becoming number one and surpassing the Immigration Lawyers Toolbox. But Immigration Review, you should definitely check it out. And we have tons of the clips on the YouTube and the Instagram page for Immigration Lawyers Toolbox. So you'll get like quick snaps of it to get you hungry to watch the whole show. So especially his podcast, Immigration Review, found wherever podcasts are found. Kevin, thanks for coming on again.
Thanks, John. Thank you as always for that lovely introduction. We do different things with our podcasts. So, you listen to one and then you listen to the other and you get it all. I'm wearing my whale shirt. This is actually the little known thing. I've been wearing this shirt and washing it every Friday since the pandemic began. And I think it's like a testament to the pandemic, but I don't think I'm going to stop. And I assure everybody it's clean. But this is how you know it's Friday if I'm wearing the whale shirt. So maybe I'll start wearing it on the podcast as well. There'll just be too many clips. If you look at all of them, it'll just be me in a whale shirt.
It does make it easy to dress up, to planning out what to wear.
That's right. I don't have to worry about it. I'll say this to everybody too. John, just listening to you every week about how you run off of all the things you're doing, it makes me very anxious. You're just doing so much. And then, what people aren't hearing is you and I talking about your two young children right before. You're doing that too. I do not have that in my life, and I don't know how you do it. So hats off to you.
I'm a stay-at-home dad first, and then immigration lawyer second, and then magazine publisher, podcaster third. And the clients always have to get first because that's risky. You don't want to mess around with that. But the kids make up all the nooks and crannies of the minutes here and there where I could put them in. And it's a lot of work. But, I don't handle the cases you handle. I would never be able to pull it off. These are like in-depth kind of cases, going to court and all this kind of stuff. I can't pull that off, the stuff I have on my plate. So I'm glad people like you are out there doing it because I can't pull it off.
Well, mutual respect. See what happens when I have kids in my life. And as I was saying, so I'm getting married in a week, so I won't be able to do this next month. But looking forward to coming back in September.
For sure. So how many cases we got this month to talk about, or at least in our snippet?
Yeah, I've only got about 3 or 4 as always. Every time I come on the show, I only look at the cases that happened in the previous month. But, from the get-go, I'll start off with 2 Attorney General cases. And I believe, if I'm counting correctly, that brings Attorney General Garland vacating Attorney General Barr and Sessions. I believe it brings the number to 5. Wow. I believe Attorney General Garland has vacated 5 prior decisions. The first were the matters of AB, so that's 2. Mm-hmm. And there was matter of LEA, the second, which was the Attorney General Barr version. And this last month, first, as so many people know, the Attorney General vacated matter of Castro-Tum in matter of Cruz-Valdez, and essentially held that administrative closure is a thing again. Yes. So the Attorney General said we're back to matter of Wu, back to matter of Advertisement, which I've probably never pronounced correctly. And administrative closure is a thing. It's a docket management tool to allow immigration judges to take a case temporarily off their docket, especially when there is a collateral form of immigration relief being applied for before usually USCIS or maybe the state court system with special immigrant juvenile status, something that could allow the non-citizen to get a form of relief or protection, but for the removal proceedings. And the best example of that, and what really did administrative closure in at the circuits, and Attorney General Gregg mentions it as well, is that the regulations expressly require that removal proceedings be administratively closed if someone's going to apply for a Form I-601A provisional unlawful presence waiver.
Mm-hmm.
And so it was a catch-22 that Matter of Castro-Tum created. You've got all these people who need it to consular process, but they can't get it if they're in removal proceedings, but you're not allowed to administratively close the removal proceedings to let them get it. And so to me, reading the Attorney General's decision, if you have a client who appears eligible for an I-601A waiver, that's going to be the most straightforward way. Yeah. You know, one of the things that I've at least been seeing a bit is that, you know, administrative closure does have very strict requirements to meet, not strict, but under Advertisement and Wu, there are these factors. And ICE, if they're going to join a motion, you know, they are bound by the law as well. But dismissing a case with ICE doesn't have all the case law surrounding it. So it seems as ICE and the courts try and get rid of this 1.4 million case backlog, that dismissal might sometimes be more appropriate than administrative closure. And so when requesting this with ICE, don't forget about, you know, just having ICE dismiss it, or a joint motion to terminate, or an unopposed motion to terminate proceedings as well.
Have you started making these admin closure requests yet, or is it too fresh?
Absolutely. I mean, we started before and certainly right after the May 27th OPLA memo from the principal legal advisor, giving guidance to ICE attorneys about when to join and what to do. And we understand that further guidance is coming, especially with motions to reopen pending at the Board of Immigration Appeals or an immigration court. And so, yeah, it's here. I think that it seems that ICE is trying to figure it out. At first, they were just accepting emails, but now it appears that most of the offices want the requests through the online ICE system. And, you know, you can only imagine the administrative nightmare that is for ICE. So it seems everyone's getting their feet under them in this new old world.
Has there been any change in the relationship you have with ICE attorneys, the communication methods, or is it too fresh from the previous administration?
Honestly, it was never great. I think it's a bit better now, but I always had a respectful relationship with all the ICE attorneys that I worked with, and they would speak to me when we had cases together and it made sense. I think it's more open now, and ICE attorneys have actually reached out to me on cases before. I don't think that was ever really happening in the prior administration, but
do you mean they try to administratively close it because they realized it wasn't a case? Is that what you mean? Them reaching out to you?
Not just admin closure, just cases. There are so many things on a case that might require attorneys to speak to each other. So, looking at a case saying, well, what about this? Maybe we could resolve this in a different way. And ICE attorneys have reached out to me, but that is not the norm. The norm has been apply for something, but then a dialogue begins over email.
Yeah.
After doing so.
But that was like banned during Trump administration, right? You weren't. They told ICE attorneys not to communicate, or was it?
It was sometimes hard to get their emails, but I was in email contact with ICE attorneys on cases I was litigating with.
I see.
If nothing else, because in some of the ICE courts, it's just an administrative nightmare, and I could file something. That attorney doesn't get it for 2 weeks. They want me to email it to them so they can get my filing. So that was kind of my foot in the door during the Trump years. Like, hey, I'll give you my filing day of if you can talk to me. So that maybe
it's good news. I mean, administrative processing, it just makes sense. It's only a bizarre world with not having administrative closure, not processing. Administrative processing is a horrible thing that I have to go through consular processing. But administrative closure with the courts, it's like it's a no-brainer. I mean, if you want to, it's a funny thing the Trump administration did. A lot of things they did ended up making the backlog worse, which kept the so-called illegal immigrants that are trying to kick out in here longer. And one of them is administrative processing. When you don't let the judge control their docket, everything's going to turn into a mess. So it's like, the left hand doesn't know what the right hand is doing. It's just mandatory. It doesn't make any sense for that not to be here. So I wish it wasn't such a political football that we'd have to have, DOJ secretaries of state or whatever, DOJ director, whatever they call them, have to change this. There's another thing that Congress needs to step up and just say, they have this authority, or maybe there'll be Article 1 courts and we can wash our hands with that. But until that happens, this has got to be statutory. It's just ridiculous.
Well, Attorney General Garland and Cruz Valdez says that they're going to publish regulations, as they said that they were going to do with asylum in the matters of AB, and it's being reported that those proposed regulations actually might be published soon within the asylum context. So it does. So the regulations are the answer. It's hard to change a regulation once they're promulgated. And so maybe admin closure will be permitted by the regulations soon, and these asylum regs might be coming out soon, and that's a big deal. And so we'll see what happens there. And but your frustration with the Trump administration is certainly shared, and it gets back to the second one that the Attorney General did just on Monday that I'm going to talk about on the podcast this coming Monday. Matter of ACAA. That would be the sixth case that Attorney General Garland vacated. Matter of ACAA was, and it's asylum. It's a domestic violence gender type asylum case that followed from the matters of AB. So it was kind of already on shaky ground because the matters of AB were vacated. And so ACAA is vacated as well. And that's not so interesting because matters of AB were already. But what is interesting in ACAA, Attorney General Barr said, even if DHS stipulates to an element on an asylum claim, like, for example, stipulates that the particular social group is immutable, like we can all agree that a woman is a woman, and that is an immutable characteristic, and that they cannot change. Although
nowadays,
maybe that's maybe that
controversial thing to say nowadays. Yeah,
you get what I'm saying, but geez.
He canceled
it. Didn't mean that. Anyway, even immutability, which is not usually contested, even if ICE doesn't contest it, on appeal, the board has to analyze every single element under asylum law, even if it wasn't contested below, even if on appeal ICE isn't challenging it. I mean, that just breaks the board. I don't know how you do that. That's crazy, unless you're implicitly just trying to get the board to deny all asylum cases and get immigration judges to do the same, which may or may not have been the intent of all of that. But in ACAA, Attorney General Garland says that's ridiculous. This is litigation. This is adversarial. If one party isn't challenging it below, if one party isn't challenging it on appeal, board, you don't have to adjudicate it. Now, he makes it a bit more discretionary, saying, on a case-by-case basis, the BIA can decide not to adjudicate it. But, I mean, that's how law works. I mean, find me an appellate judge in the circuits that's going to decide to address an issue that the appealing party isn't bringing up. I mean, it's the opposite. If you don't bring it up, it can't be addressed because it's not exhausted. So, good on Attorney General Garland. That is just a procedurally absurd rule that I don't think serves any purpose but to try to use procedure to lead to more asylum denials.
Yeah.
And so that is gone, and it didn't seem fair, and good riddance.
That's the wacky world of immigration. Like any lawyer who comes from any other litigation background and sees this is like, what's going on here? This is practice.
It's a Wild West, but the Wild West can be fun too. So that's matter of ACAA. So that is vacated by Attorney General Garland. As I'm going to say on the podcast, maybe Attorney General Garland can set his sights to matter of Thomas and Thompson next. That was a immigration case about convictions that made it much more difficult to get relief if a conviction is vacated. Not going to get into that, but I don't know. Thomas and Thompson. If Attorney General Garland is a listener, a watcher to the Immigration Lawyers Toolbox, Thomas and Thompson.
Well, we do have DOS employees for sure who watch, and EOIR clerks that know who watch. I'm not sure how far up it goes with the food chain, but clerks.
How'd you learn about the EOIR clerks?
They just contacted me. I used to be a clerk. I used to listen, that kind of stuff. And the consular officer told me. They haven't there USCIS. Maybe some USCIS go every once in a while, but that's about it.
I've got stickers now for the Immigration Review podcast. I gave a sticker to a USCIS officer at my last interview.
Oh, that's cool.
He liked it. I had to feel it. I didn't want to do it if we weren't already on good terms, but he liked it. So I gave him a sticker. So I don't know, trying to sneak my way in.
Yeah. I think you respect your craft enough to spend so much time on it. I think most of the officers will be like, oh, they see you, they'll come at you different aura. And frankly, just doing the show, it's kind of a weird thing to say, but when I do talk to listeners and stuff, it's kind of like talking to a celebrity because they hear our voice, the voice of God from their ears. There's a special relationship you have on these kind of stuff, and if they hear you, it's definitely going to help your case, unless they just hate immigrants or something like that, which nothing you do about that.
It's definitely fun. It's definitely cool. Look, I'm definitely, I say definitely 4 times in one sentence. I am doing it for Respondents Counsel, for Non-Citizens Counsel, but 75% of the cases are against the non-citizen. And regardless, I hope a USCIS officer or an EOIR judge, law clerk is not trying to deny. My podcast lets them know what the case is. I'm still going to review the 11th Circuit case that found all of Bangladesh support terrorism. I still reviewed that, and that's important for them to know in the 11th Circuit because the law is the law. You don't try and hide law. So hopefully it serves a purpose.
That definitely is. It's good to keep up, but that Bangladesh one's pretty wacky. So many wacky things to pop up.
Crazy.
Did we talk on the show, or how did I know about that? You probably told me about that.
Maybe. Definitely, obviously on the podcast, Islam v. DHS. I just love the name. So appropriate.
Yeah, I remember that we talked about that.
Yeah, it's good. So to the good, Portillo Flores v. Garland out of the 4th Circuit. The 4th Circuit has the best asylum case law, it seems to me, in recent years, and certainly when it comes to El Salvador and MS-13. And Portillo Flores is the 4th Circuit going en banc and overturning a decision that it issued in 2020. It's really mostly about children and asylum, and it's just got great quotes. And if you have a child asylum case, you got to look at Portillo Flores talking about how age is a critical factor and it can turn non-persecutory conduct into persecutory conduct because a child it's essentially a lower standard. That persecution to a child's parent or family member, that could be persecution for a child, and probably is, because again, the child's mind, that a child isn't expected to report the harm to police because again, he or she is a child. So it's just, you got to read Portillo Flores v. Garland if you've got a child asylum case.
This is a whole thing of the unaccompanied minors. This is going to be a big a consequence of that, right?
Well, I don't do special immigrant juvenile stuff. And so an unaccompanied minor can get a green card, essentially. They have a path to a green card, to paraphrase, if a state court finds that they are abandoned or neglect and it's not in their best interest to be brought back to the child. Again, it's not what I do, but they don't have to make a whole asylum claim to get special immigrant juvenile status. But if you don't get special immigrant juvenile status and you are a child in asylum, or if you were a child when the persecution happened, but now you're not, that would still, Portillo Flores to me still could support an argument that it was persecution back then. So there has been a past persecution showing. And the second you have that means the burdens flip, and it's DHS's burden to show that conditions have changed. There's been a material change in conditions, or you can reasonably relocate. Now, the argument would be that there has been a material change because you are now an adult. But I'd still rather be in that argument with DHS having the burden than at the first stage of trying to show that it was persecution. So, Portillo Flores, if there's children issues involved, and there's also good stuff about how immigration judges cannot rely on general country condition evidence about MS-13 in El Salvador to undermine some non-citizen specific occurrence. Because the Department of State report, it's always going to say that the Salvadoran government's trying.
Yeah.
That's only relevant if it ties into the actual claim, the specific claims before him. So says the 4th en banc in Portillo Flores.
Which one? Where's the 4th? You know what states?
Definitely Maryland.
Okay, that area. Okay.
Virginia. And I'm not sure what else.
Okay. Here's an idea what areas to practice, but no, it's en banc, so it's kind of a lot more popular to go everywhere.
And and I say it on the podcast, and it cites to a lot of other circuit decisions. I mean, there are similar decisions like that in the Ninth Circuit and a few others. So, that's what the decisions usually point me to the other circuits that they agree with. And then you go to those decisions and you make it in your circuit.
Very good.
And not to just play in the 4th and the 9th, but I want to end with the 5th, which so rarely am I excited about a 5th Circuit immigration decision. But in Guerrero Trejo v. Garland, it's a non-LPR cancellation of removal decision, and it doesn't end well for Mr. Guerrero Trejo. So I want to temper my excitement. But it's just such a great decision on jurisdiction. And as I've mentioned before, and I'm not going to get too deep into jurisdiction, but the Kurzban law firm, IRA, and with Wilmer Hale, we've got a Supreme Court case coming up at the end of the year called Patel, which the Supreme Court will decide whether or not the 11th Circuit went too far afield in its Patel and Bonk decision, which conflicts with pretty much every other circuit on a jurisdictional issue. And decisions like Guerrero Trejo out of the 5th Circuit, they really help Patel in certain ways. And to summarize it, an immigration statute, INA Section 242 A2B, it essentially makes it such that the courts lack jurisdiction to review the discretionary determinations made by immigration judges and the Board of Immigration Appeals, and at least when it comes to certain forms of relief. And that is very much paraphrasing the statute. So what does it mean to be a discretionary determination? Because all these forms of relief are discretionary. At the end of the day, cancellation, adjustment of status, it's at their discretion. Does it mean that they can't review the entire form of relief, even if an immigration judge makes a crazy holding because it's discretionary? Does it mean that you can't review exceptional, extremely unusual hardship because that's kind of discretionary? Or does it mean that once all of the elements are satisfied, for example, cancellation of removal, which requires 10 years in the U.S., that you have good moral character, and that you're going to have exceptional, extremely unusual hardship to your qualifying relative, once all those 3 or 4 things are met under the statute, an IJ can still deny as a matter of discretion. Does it just mean that the circuit cannot review that final decision to deny as a matter of discretion? The Fifth Circuit said it's that it can review everything, including whether or not the hardship meets the exceptional, extremely unusual hardship standard. It can review all of that. All it can't review is whether or not an IJ, and this is to quote them, is going to grant it as a matter of grace. That's a big ruling, especially in the Fifth Circuit, which isn't always so non-citizen friendly. And it's based a lot of this part of the jurisdiction fight, which isn't necessarily what's at issue in Patel, is stemming from a Supreme Court decision 2 terms ago that Mark Prada and his law firm and their co-counsel argued before the Supreme Court in Guerrero Asprilla, which was in a motion to reopen context. But it really is, it's opening the door, saying that these mixed questions of law and fact, the application of undisputed facts to a legal standard, is reviewable. And from there, you've got these circuits that are saying we can review more stuff now. We might not want to review more stuff now, but the Supreme Court has said that we must. So that's a very complicated issue in 5 minutes, but it's an interesting decision. And when you've got the Fifth Circuit issuing decisions like this, it seems to point in a very good direction for circuit jurisdiction on relief. Very
cool. Well, that's some good news.
Right, it's good. Listen to the podcast if you want to hear more with it. Jurisdiction, every time, even before I was going to talk to you about this, I had to whip out the statute. Every time I start talking jurisdiction, I have to review my notes and the statute. I'm like, wait, what does it say?
I have a consultation today. They're gonna have an adjustment interview in the 5th, and they filed asylum, have TPS now. And they won the diversity visa lottery. That filed for asylum once when they had a B1, B2 expired, so they may not have maintained status, so that could be an adjustment problem. But each field office is handling that differently. But since he has TPS, I'm like, well, in one way, it'd be a good case to appeal if they deny it, and finally bring this case up on a circuit level of what is, unreasonable delay or whatever it is. But he's in the 5th, so I'm like, I don't really want to push the issue and make a decision in the 5th. I'd rather be in the 9th.
Yeah, well, that's interesting though, and this is not legal advice, and I haven't given it any thought. But forget it. Putting aside that he's in a status authorized by the Attorney General with an asylum application pending, TPS, the Sanchez v. Mayorkas analysis expressly was because the TPS statute says, to paraphrase, that they are to be treated as if they are maintaining non-immigrant status.
We had TPS after he's from Venezuela, so it was announced like.
Oh,
so
he just got it. Okay,
yeah, it was a 3-year. I mean, he just applied for it, so it's probably pretty soon. So there was like a 2 or 3 year gap where the asylum case is pending, and I've seen field offices approve those for adjustment. I've seen a lot not. So in Florida, various Florida offices, Virginia, that area, I've seen people send me denial notices, not accepting the matter of LK decision as. Matter of LK is so weirdly written. Like, it's just, why don't you just pull the trigger? It's like half cocked, kind of like for those who don't know matter of LK, you should definitely read it. Matter of L as in Lincoln, K as in King. That's such a big issue. And before, I used to talk a lot about the inconsistencies in TPS, and Ninth Circuit does it. The Supreme Court shot down the positive version of it for immigration lawyers and clients about TPS. So I stopped talking about that. The next thing I'm going to talk about a lot is this matter of LK. Not being consistently applied and vague. So that's I see more and more of it happening because of the asylum delays where people want to adjust for various reasons and they can't, depending on which jurisdiction they're in.
Yeah, I haven't read Matter of LK in a while, but I remember reading and leaving like, wait, what? Like the head spinning. What does it actually mean? I wonder. I don't know. I'm not so cynical on the board. Like, I think that even though I disagree with maybe a fair amount of board members right now on a view of the law, like, I'm sure they're all very smart and that they could draft very clear immigration decisions. And I think a lot of the recent ones have been very clear, but sometimes I wonder, no matter the court, if they're not clear for a reason, if it's because there's jockeying behind the scenes and one of the judges on the panel is only willing to go so far, so you get this half written decision that could be more clear, but you don't have the votes for it. I wonder if that's what's happening behind the scenes.
To me, it's got to be, because matter of LK, it's like half the story. It's like, how do you make a decision about like a portion of a, like, it just, you got to do the whole thing. So essentially they're saying that if the asylum office denies the case and you're sent an NTA, that means you're no longer, we can say you're no longer in status, but we're not going to make comment on what was the situation before that. So it's like, well, make a decision because there's cases that affects. So please say it. Or more importantly, regulations need to pick that up and just draw a line. I mean, whenever I say that, it's going to end up being to the negative of what I want.
Yeah, regulations are great now. Regulations made my heart flutter, skip a beat when it was the Trump administration who was going to do all the regulations. So regulations are only as good as the administration in power.
And that's the thing. So one of those aspects of immigration reform, if there was going to be some big package, this is something I want clarity on. When it's the fact that part of the agency that there's delays, you should be able to maintain status for adjustment to 45C on that argument. The Ninth Circuit, in the last case they had on this, they had a footnote that kind of said, they didn't argue this, they should have, but we may have looked at it differently. So that's why if the case was Ninth Circuit, I was saying, we'll get some money with pro bono, we'll file this appeal and try to get something going. But the client's in the 5th, and I wouldn't really want to mess around with that and have some bad case lock them out.
No.
Yeah, a lot of strategy.
Wild.
Yeah. Well, thank you so much for coming on the show again. Congratulations on getting married, honeymoon. Look forward to seeing you come back with the tan. But you're in Southern California. I guess you're not getting more tan than this, as hot as it is here.
That's right. And I might come back with COVID, so I'll let you know. That'll be a different look.
Yeah. Which variant is it that they have there?
Everyone's got their own variant at this point. So, it's just I'll try and rack up as many variants as I can.
There you go.
You know what? Shouldn't make the jokes. COVID's very sad. I take COVID very seriously for anyone who will ever watch this.
But you got to get the most of this stuff. We've been locked in our house for so long. Just kind of have fun with it.
It's also, I mean, I'm no don't have any medical knowledge, but like, right now it seems that the vaccines that we all have are the strongest they might ever be. It seems like these variants might be with us for a long time, and eventually the vaccines won't be so strong. I don't know. It's a strange new world we're entering.
This is terrifying, but apparently like the Delta one that's going around is like really hardcore, but the really bad one is the South African variant because it crossed between mice and humans. So that means we're never going to get rid of it because the rats and stuff are going to have it.
I'm going to South Africa on my honeymoon. I look forward to this.
Well, probably won't get it.
Probably be fun. Yeah.
I've been to Disneyland and Universal Studios in the last 30 days. And of those places, I mean, they have pretty much shut down B2 travel. But if I was going to get one of these, I would have got it by now. I've got Pfizer vaccine, so I made it. So I've been okay. I think it's these things like it goes to how well your immune system is, how tired you are and stuff. So just make sure you rest on the plane, eat well, that kind of stuff. And you got your vaccine. Honestly, with like in South Africa, they had the looting that happened. If it was going to be a big jump in spike in things, we would have heard about it from the World Health Organization. That South Africa's on fire and all that kind of stuff. There's some method to this virus mayhem, so I wouldn't be too worried. Again, I went to Disneyland and with no mask, into Universal Studios no mask, and it was packed. We did okay.
Thanks for the kind words. If I don't come on September, everyone will know why.
Well, definitely keep us posted. I look forward to hearing good news and having you back on the show.
Bye, John. Have a great month.
Bye, Kim. You too. Bye-bye.